Citizens United vs. the Federal Elections Committee. Citizens United was a non-profit organization who ran a documentary on the then presidential candidate Hillary Clinton entitled Hillary the Movie. The film by nature was critical of Hillary Clinton, and Citizens United sought to air it and advertise for the film in the weeks and days leading up to the election. This was in violation of the Bipartisan Campaign Reform Act, as noted by Justice Anthony Kennedy in his deciding opinion. Section 444B makes it a felony for all corporations, including nonprofit advocacy corporations, either to expressly advocate the election or defeat of candidates or to broadcast electioneering communications within 30 days of a primary election and 60 days of a general election. Section 444B's prohibition on corporate independent expenditures is thus a ban on speech, as even both candidates in this past general election theorized that money being kept out of politics is the last hope for our republic, which is ironic. Generally speaking, most people want money out of politics, and most politicians and civilians are alike dumbfounded that the Supreme Court could declare money to be free speech and corporations to be essentially people. I offer a word of caution with this interpretation, as neither of those two phrases are used in Justice Kennedy's decision. Now, some constitutional background would serve us well. The Constitution should be interpreted as a contract the same as any other, and this is because, according to Black Legal's dictionary, it matches the requirements for the statute or frauds, which is the basic legal makeup for contracts. In contractual law, there is no such thing as implicit clause. This is vitally important because it means that there is no interference in the government's power. Either the government does act with legal authority or it does not act with legal authority. If there are no implicit legal clauses, then there is only explicit. If you've ever wondered why Article 1, Section 8 gives Congress the power to establish a post office, it's because the Constitution is extremely specific, and because implications don't exist in this legal field. What you see and read there is what you get, period. So if what is written in the Constitution is the full scope of the government's power, then what about our own rights? The Constitution does not give us rights. It simply acknowledges our natural rights and swears to be contractual bond to abide by each acknowledged stipulation. However, we have a responsibility to exercise our rights, or else the legal concept laches might be viable. Laches is a French word meaning a species of action wherein a party of reasonable intelligence and integrity, having the right to take an action as a prescribed law and having failed to timely do so, loses all rights to proceed. Basically, if you fail to exercise your right in a legal setting, you lose all right to do so. These concepts tell us what the government can and cannot do strictly, and Madison v. Marbury, 1803, establishes the supremacy of the Constitution over conflicting U.S. laws. And although controversial, Justice Kennedy is essentially acknowledging that corporations are made up of people, and in our legal system, the government simply does not have constitutional authority to restrict natural rights. Natural rights, as constitutionally prescribed, being the determinant factor involved. If it did have such authority, it would have been outlined in the Constitution, because again, there are no implicit clauses in a contract. Or in the form of a question, since when does the state ever have the constitutional authority to force you or your colleagues into political silence? This is a very thing fought against, which founded the freedoms we have now acknowledged. So what is the solution if you are really opposed to Justice Kennedy's decision? Amend the Constitution to explicitly state what functions of speech and by extension political expressions may be limited, and what far-reaching implications that would mean. It would be wrong to suggest the limiting of any capacity of natural rights, explicitly acknowledged for any personal, political, moral expediency is a viable solution. This is why this case is so applicable to economics as a social science, especially a social science so dictated by government, public, and private decisions. Thank you for your time.